Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
I'm feeling good today, and for a number of reasons. First, I'm coming to you from the road, none other than from the Big Easy, for Mardi Gras. Actually, no, to visit my brother and new niece, but it is Mardi Gras. At 38, my desires now fall more in line with the king cakes and beignets than with Bourbon Street chaos. Can it be both? Time will tell. But also because I just came from the Ayla, Georgia, Alabama chapters conference, and it was a knockout. Really well done, guys. As I understand it, demand to attend the conference was so much that they actually had to turn lots of people away, despite getting a really large venue. I can only imagine that the added interest from the bar is partially a result of the scary times we find ourselves in and a desire for community, something that the Ayla chapters never fail to provide. And maybe it was also because Ira Kurzban came up from South Florida to give the keynote speech. And let me tell you, he knocked it out of the park. Reminding us all who we are, why we are immigration attorneys, the power we have together, and the knowledge that we possess individually. Telling us stories from his time representing Haitians in the 70s and the 80s, and how actually what's happening now in immigration might not even be as bad. We've been here before, and we've won before. But it takes a lot, and some federal judges, to know right from wrong. The lawsuits have already begun, by the way. Quoting from that AUSA's letter in the Southern District of New York relating to the Eric Adams case, Ira challenged, nay urged, all of us to continue our small acts of courage each and every day. Because that's how you beat them. Amen, Ira. Amen. Now, it's time for me to courageously discuss the two cases this week. Both wins for non-citizens. And one straight to you from KKTP. First up is Zia v. Scott, published by the 8th Circuit on February 27th, 2025. This case is about international adoption. It's a short case, like so many 8th Circuit decisions are, but it's a KKTP win. The firm, where I'm also a partner. So I've naturally got some inside scoop and some things to say. Miss Zia is the biological aunt and adoptive mother of Tian Zia, known here as Tim. Tim is from China, and his parents are EB5 investors. No gold card members yet, but I don't know, maybe soon? What is law anyway anymore, am I right? Tim was born in China in 1997 and lived there until August of 2011. But at 14 years old, his parents sent him to America on a tourist visa where he stayed with his aunt, U.S. citizen, Miss Zia. Quote, Tim's parents viewed the visit as an opportunity for Tim to begin adjusting to American way of life in anticipation of what might be an eventual immigration to the United States. Miss Zia enrolled Tim in middle school in Dallas so he could expand his education before returning to China. End quote. But see, despite having to invest a lot of money in America to get their green cards, EB-5 immigrants still have to wait a long time. Like, a really long time sometimes. We'll see what happens with Mr. Trump's gold card, but don't hold your breath. It sometimes does take a long time, for example, to make sure that the funds used to invest in a U.S. project were obtained from a lawful source abroad. Again, assuming the U.S. government continues to care about such things. Don't get me wrong, there was nothing wrong with Tim's parents' money, but these things take time. And as Tim's 6 months in the United States began to run out, his parents decided, quote, to avoid upending Tim's life, to relinquish their parental rights. In September 2012, Ms. Zia adopted Tim. About 6 months later, Tim's birth parents immigrated to the United States and began living in the same neighborhood as Ms. Zia. Tim continued to live with Ms. Zia and her husband until Ms. Zia lost her job in February 2014 and relocated. Tim then moved in with his birth parents to continue attending the same school. End quote. Tim began studying at Emory in 2016 and credits his adoptive mother, his biological aunt, Miss Zia, for his successes. But now Tim has a problem, arguably of his biological parents' making. They have green cards and maybe even citizenship now, I don't know, through their EB-5 investment. But Tim is no longer their son. Tim wants a green card. The green card adoption process can be very complicated, and the first thing that you need to figure out when doing these is whether the birth country is a party, like the United States, to the Hague Act Adoption Convention or not. China is a party, meaning that the Hague Act process applies. But for reasons unexplained by the Eighth Circuit, but I'm pretty sure are true, Tim's unique situation precluded him from obtaining a green card through the Hague Act process, given everything that happened in America. That means Tim's only option for permanent status in the United States, at least at the moment, is for his adoptive mother, U.S. citizen Ms. Zia, to file a Form I-130 petition for him. But he can't do that under U.S. law if the Hague Act process applies. Despite China being a Hague Act party, the process doesn't apply if Ms. Zia submitted sufficient evidence with her I-130 petition, quote, showing that Tim was habitually resident in the United States at the time of his adoption, end quote. That is a way around the Hague Act adoption process, even for Hague Act countries. Ms. Zia timely filed the I-130 petition in 2018. To meet the habitual residence in the U.S. requirement, or for that matter, residence in any other Hague Act country that's not China, and that could then avoid the Hague Act process, USCIS guidance calls for, quote, 1. A written statement from the child's country of origin, indicating the child is no longer deemed habitually resident in that country, or 2. If the petitioner cannot obtain a written statement, evidence that the petitioner meets the intent, actual resident, and notice criteria, end quote. Full disclosure, we disputed the correctness of this policy before the Eighth Circuit, but the court skirted that dispute. USCIS denied the I-130 petition, not only finding the evidence insufficient for Ms. Zia, but believing Tim entered on his tourist visa for the purpose of adoption, which is another way to deny the I-130 because it effectively means Tim tried to get around the Hague Act process, and you can't do that. The appeal of USCIS's denial goes to the BIA, which affirmed USCIS. We came along and sued in district court, but did not succeed. But we did before the Eighth Circuit, here. The all-powerful Administrative Procedure Act requires agencies, be them USCIS, the BIA, etc., quote, to give a satisfactory explanation for its conclusions, including a showing of rational connection between the facts found and the choice made, end quote. For all you petition for review or district court challengers, quote, an agency decision is arbitrary and capricious if it fails to consider an important aspect of the issue or provides no meaningful explanation for its conclusions, end quote. In such cases, it's not a possibly unreviewable reweighing of how the agency weighed evidence if the agency didn't consider an important piece of evidence at all, explains the Eighth Circuit. Under those circumstances, it's just a straight-up APA violation. In this case, the court explained, the BIA considered that before his adoption, Tim resided with Ms. Zia, attended school in the U.S., and participated in religious and extracurricular activities. And indeed, he did. The BIA may have even relied on some of that to affirm USCIS's belief that Tim's parents always had the intent to have Ms. Zia adopt Tim, heavily disputed. In fact, we did provide evidence showing that at the time Tim entered the U.S. and for some time thereafter, Tim and his parents intended for him to return to China before his B-2 visa expired. In any event, after considering or at least mentioning the ties that Tim had to the United States before his adoption, the BIA, quote, concluded, without any further explanation, that Tim's ties were not compelling enough to demonstrate his habitual residence in the United States, end quote. How can that be, reasoned the Eighth Circuit? The BIA certainly never explained, quote, which specific facts and circumstances it considered and how those facts negated Tim's documented connections to the United States, end quote, before his adoption. And without doing this basic thing, the Eighth Circuit can't be sure that the BIA was right, or that it didn't simply arbitrarily and capriciously deny Tim's case. The Eighth Circuit didn't say this, but now at this point, the life of someone sent here as a child and who has lived and grown up here for 13 years, not to mention who has been educated at a premier U.S. university, is at risk. I don't believe Tim has any other option at present to obtain a green card like his biological parents did, but for the I-130 petition from his adoptive mother. So he deserves a reasoned explanation, reasoned the Eighth Circuit, in its remand to the agency. Meaning, congratulations to my partners, Ed Ramos and John Pratt from Kurzban, Tetzeli, and Pratt on the win for Ms. Zia and Tim. Special congrats to Ed for kicking butt at oral argument. And that is Zia v. Scott.
Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited.
Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMREVIEW2025. Keep up and join the good fight. All right. Our final case is United States v. Parham, published by the Fourth Circuit on February 26, 2025. It's a sentence enhancement crime of violence case. Mr. Parham has a conviction for Virginia common law robbery in violation of Virginia Code Section 18.2-58 from, it appears, 1978. Doesn't matter how old the conviction is, though, I don't think. If the conviction matches the sentence enhancement definition of a crime of violence, he's going to get a lot more prison time for his far more recent federal conviction of being a felon in possession of a firearm. Ironically enough, I wouldn't be surprised if it's the 1978 conviction that made Mr. Parham a felon in the first place. A district court judge held that the conviction is a crime of violence. But the Fourth Circuit says it's not. For immigration purposes too, then. Because the crime of violence definition at INA Section 11843F is materially identical to this definition here. To qualify for sentence enhancement purposes, the Virginia offense must require the use, attempted use, or threatened use of physical force. Physical force equates to violent force under Supreme Court precedent, and under Supreme Court precedent, Bourdain. The Virginia crime won't match the crime of violence definition if it permits conviction indivisibly with a reckless mental state. Why doesn't the Virginia crime match the definition here? Well, said the Fourth Circuit, because, quote, Virginia robbery can be committed by threatening to accuse the victim of having engaged in sodomy, end quote. Don't get me wrong. It is very hard for me to imagine how that crime plays out in practice. Robbery through accusation of sodomy. But you gotta admit, that doesn't require the use of force at all. It just requires, I suppose, a victim who would be really offended or embarrassed about having been accused of sodomy. And apparently that victim actually exists, or could reasonably exist in Virginia. Not that that's necessarily the correct application of the realistic probability test in the Fourth Circuit, don't get me wrong. No. Because heck, this all follows from the Fourth Circuit's decision United States v. White, published in early 2022, that I could have sworn I mentioned, but maybe I didn't do a full case summary about it. And that case had in turn relied on the Virginia Supreme Court's finding that robbery in Virginia, quote, does not require, as an element, the actual attempted or threatened use of physical force, end quote. The Virginia Supreme Court then said so specifically with this robbery through sodomy allegation thing in its own White decision. That is a possible way to convict someone of robbery in Virginia. So there you go. Again, I had forgotten about all of this, which just goes to show you what's happening in my brain. But that's a very powerful quote for the categorical approach, which essentially treats state Supreme Court decisions that explain the element of a state crime as gospel. Yes, the Fourth Circuit's White decision was in the Armed Career Criminal Act context, another way to essentially enhance federal prison sentences, but, explained the Fourth Circuit, it's the same analysis as the sentence enhancement context at play here. So too then with the immigration crime of violence definition, says the Kevin. Anyway, the Virginia Supreme Court has held that threatening to accuse someone of sodomy is, quote, the legal equivalent of putting someone in fear of bodily harm, end quote. I mean, I guess. I certainly haven't met such an individual since middle school, but I guess. I must ask, who among you, dear listeners, is so affected by a sodomy allegation that you would hand over your property to a would-be robber? But so be it. It has saved Mr. White, and now it's saved Mr. Parham from some months in prison. Because being accused of sodomy is not a violent thing and doesn't require any physical force or threat of physical force. quote, it is simply a threat to tell someone else that the victim engaged in sodomy, which is effectively an attack on one's status, as opposed to a physical assault, end quote. I guess. And it meant that for this and another unrelated reason, the matter was sent back to the district court for further sentencing analysis. It also means that regular Virginia robbery is probably not a crime of violence for immigration purposes. And it means, as so often is the case, congratulations to the federal public defenders of this great nation, particularly here, Jeremy C. Kamens from the Alexandria, Virginia office. A heads up before we conclude the episode. Beware with all this, it would appear based on a footnote that Virginia may have amended its robbery statute in 2021 to make the various ways of committing robbery distinct elements of the offense, thereby possibly undermining this decision right here for post-2021 robbery offenses. Analyze it all yourself, and again, heads up. But this case remains binding for all pre-2021 amendment Virginia robbery convictions. Then again, to convict in Virginia, the Virginia Supreme Court has held that the use or threat of violence, quote, need only be slight for anything which calls out resistance is sufficient, end quote. So I don't know, maybe that is a crime of violence and maybe that's not, even after the 2021 amendment. Maybe there are more arguments to be made, assuming that the statute is now relevantly divisible. I don't know, certainly beyond the scope of this decision, but give it a heads up if your robbery conviction in Virginia is after the 2021 amendment to the statute. And that is United States v. Parham.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.